All right, all right. I have some amazing people here with me today. For anybody that don't know y'all, which they must be under a rock. But if they don't know y'all, can y'all please say who y'all are and what y'all do?
Derrick, go for it.
Sure thing. My name is Derrick Leday. I'm a public insurance adjuster licensed in Texas, Minnesota, and Louisiana. I also do some insurance appraisal work and umpire work and estimate consulting work as well.
My name is Caeden Tinklenberg. I'm the co-founder and CEO of Swift Public Adjusters. We're a public adjuster firm. Our residence is in Iowa, but we also work in many of the surrounding states in the Midwest as well.
And I'm gonna let y'all get into it because Derrick brought this to my attention and to the Policyholder Preservation Association of America attention. So I know he's a little bit more invested as far as the best questions that's been weighing on his mind to you, Caeden. But I know from experience, the people in our industry, when it comes to reading page after page to make it more likely that we win an argument 2 months from now, we can do that. But when it comes to watching the video, we need to get that right up front. So just right up front, can you just give the headline and what people from policyholders to experts can do that can help you? Like the headline of what's happening and how we can help. And then we're going to get into the details.
Yeah, so what's happening is that the Iowa Legislature is pushing through a bill that would abrogate the 2018 Walnut Creek versus Depositors Insurance Iowa Supreme Court case, which confirmed that the appraisal panel has the authority and duty to determine issues of causation and scope of damage when conducting an appraisal. And the legislature is wanting to pass this bill that would specifically state that the appraisal panel does not have the authority to do that, which would completely, abrogate, overturn the precedent set by that 2018 Supreme Court case. So what we want to do is stop that bill from moving forward. So if you're in Iowa, you can contact your legislators, your House representatives, and your senators to oppose this bill. If you're not in Iowa, you can join some of the associations that are active here in Iowa to fight this bill. The American Policyholder Association, the American Adjuster Association, United Policyholders is also getting involved. If you're a public adjuster, APIA, American Association of Public Insurance Adjusters, and NAPIA, National Association of Public Insurance Adjusters, are both involved in this effort as well. So join those associations, contribute to their efforts, because they are out here advocating for consumers who don't really have a voice otherwise.
Absolutely. And I know you said Google your, it's House File 2299 and Google find your legislator. All right. Yep. I'm just a fly on the wall. I want to hear what y'all, because Derrick was so concerned about it, man. So please.
Yeah. I think it's a really, really big deal. And now we got the basic facts out there and what we can do. But as far as specifically in Iowa, under the current, statutes, under the current laws, what are the conditions and the remedies, for a policyholder, for a property owner, if they have an insurance claim and the insurance company sent their guy out and he's not seeing it the way that they need? What can you do now the way it is? What options do they have available to them?
Yes. So Iowa is one of the states that has adopted the standard fire policy. The standard fire policy is the minimum standards of insurance for any property and casualty underwriter that's selling insurance to consumers in the state of Iowa. Part of the standard fire policy in Iowa, which is based off of the 1943 New York standard fire policy, also called the 165 lines. Part of that standard fire policy is the appraisal clause. So by statute, appraisal must be included as a remedy for policyholders that have a dispute over the amount of loss on their insurance claim. And so the amount of loss is kind of made up of a couple different things, specifically the cause and the scope of the damage, and then what the repair methods are, and then what it's going to cost to make those repairs. So currently, as the law stands, if there is a dispute between the policyholder and their insurer over what the amount of loss is, appraisal is available to them currently under the law, and it has been since the standard fire policy was enacted many decades ago. So that's what they can do. They could also file suit, but aside from that, there really are no other remedies for amount of loss disputes. You have appraisal and you have litigation.
Okay. And that appraisal is typically written into the insurance policy, and in my understanding, as an alternative to litigation, meaning it's supposed to be a quicker remedy and a more affordable remedy to litigation. Now, I know in a lot of other, jurisdictions, attorneys are able to get involved, and there's, compensation when the insurance company doesn't do the right thing, and they require an attorney to get them to do the right thing.
Correct.
Is that not strong in the Iowa law now?
Correct. Yep. So there's no fee shifting provision for attorney fees in the state, and there's no also private right of action on breaches of insurance regulations, the Unfair Claims Settlement Practices Act. You can't sue on breaches of that. You can sue for bad faith and breach of contract, but you don't have a specific right of action if an insurance company does a specific thing in violation of the Unfair Claim Practices Act. But even if you win that, there's a very small chance, a very high burden that you're going to get your fees covered in any punitive damages. So it doesn't make a lot of sense to pursue litigation, if at all possible, on any of these claims, like it might in other states like Nebraska or Florida.
Okay. So with the no fee shifting, that basically means that the property owner right now, if they retain an attorney, which is one of the 2 or 3 dispute remedies that they have in their policy, that they're going to have to foot that bill, which could be 20, 30, 80,000, and depending on how far that goes, if it goes to trial, if it goes through appeals and all that stuff.
Exactly.
And then you're saying that they're not going to be able to recover those attorney fees. And then also, regardless of the action that the insurance company takes, they're probably not going to be able to hold the insurance company accountable for that. So the worst case scenario is that the insurance company is going to pay what they owe, and that policyholder is going to be out an extraordinary, just a huge sum of money. That's basically how that's working right now.
Yep, exactly. There's no current statutory mechanism for policyholders to recover the costs that they incur when their insurer intentionally underpays or wrongfully denies the claim.
So maybe that's something that the legislators and that the people watching could be asking their legislators to be tackling, is giving them more rights and allowing them the opportunity to get attorneys involved and have a cause of action against insurance companies that aren't doing the right thing. But we do have appraisal now. So what is the scope and authority of appraisal panel now, and how is it going to change if this legislation as it's proposed were to go through?
Absolutely. So presently, the appraisal panel has the authority to make any determinations of fact relative to the amount of loss. That means pretty much everything is within their purview, except for interpretation of what may or may not be covered per the terms of the policy. But as far as determining what caused the damage, when the damage occurred, anything that follows down that line of determining the amount of loss, they have the authority to decide and include in their award.
Okay, so it sounds like if there's a dispute with the insurance company right now, the policyholder can demand appraisal. And whether the insurance company said that that's damaged, it's not damaged, or it's damaged by something other than, the panel has the authority to say definitively this is damage from this loss, and this is the amount that's owed under that damage. That's correct?
Exactly. Well, not necessarily how much is owed, because coverage may preclude that damage from being covered under the policy, but it would say this is the amount of the loss. This is how much, the insured was damaged by whatever the cause was that's being claimed.
And if I'm understanding this legislation correctly, and I haven't reviewed it, so please correct me if I'm wrong, but what it's saying is that you'll only be able to go to appraisal for what the insurance company has agreed is damage. Is that right?
That's exactly correct. Yep.
So instead of us saying, for example, the roof is damaged and the insurance company says the roof is not damaged, now we go to appraisal, it's obviously damaged and the appraisal panel is easily able to make that determination, that would not be an appraisable issue.
Yep. Yep.
So if the property owner, they can't, feasibly, reasonably, and it doesn't make financial sense for them in most instances to get an attorney to represent them.
Mm-hmm.
And now they have no ability to go to appraisal unless the insurance company says, yeah, we want to give you a shot and we might want to pay for this. What are they going to be able to do?
They're not. They have no remedies other than suit. If their insurance company doesn't want to acknowledge that something was damaged by the peril being claimed, and that this law would give them the unilateral authority to do that, their only remedy would be to sue. It's very, very unfortunate.
So pretty much everyone would be self-insured. And then depending on the profitability of the insurance company and how much they decide they want to pay out for your loss, you just kind of be hoping that they pay you regardless of what the contract and policy says.
Effectively, yes. The proponents of this bill are saying that the appraisal process has been expanded and is being abused by policyholders and by those who advocate for the process, like attorneys and public adjusters, that it was never intended to resolve these types of disputes. That's what they're claiming. But if you take that for what it's worth, effectively the result will be exactly what you're saying. The insurance company having the unilateral authority to determine what the scope of the loss is, what the cause of the damage is, and if you don't agree with that, you're going to have to sue them.
So it's really going to put, because I mean, the average American can't come up with $1,500, $2,000 in a crisis, right? And obviously an insurance claim is something that's unexpected. So it's really going to effectively be basically removing coverage from almost every policyholder in the state of Iowa. They're all going to basically lose their rights.
Yeah, that's the exact intent of the bill, is to restrict the rights of the policyholders to have their disputes over causation resolved by an appraisal panel.
Is there any way that you're able to see anything in this bill that's going to benefit the policyholders, the property owners in the state of Iowa?
No, there's nothing in this bill that does anything except for harm policyholders and benefit insurance companies. During the subcommittee hearing that we had this past Monday, one of the proponents of the bill said that if this bill doesn't move forward, right, he was in support of it, then everybody's premiums are going up. So I suppose I could give credit to their argument in theory that if this bill goes forward, that premiums will go down. But I'm never seen that happen. No,
yeah,
there's nothing in this bill that will benefit policyholders.
Yeah, and up or down, it's it could be up $1, it could be down 50 cents. If you have no coverage, you have no coverage. If you're self-insured, it doesn't matter what that premium changes.
Yep.
You're never going to be able to recoup that.
Exactly.
So this is really grim. I mean, this is an absolute attack on the property owners and policyholders in Iowa. And so since we got you here, and this is obviously a horrible piece of legislation for anyone that owns property and isn't able to self-insure, what would you ideally like to see happen in Iowa? What changes should the legislature be making?
Yeah, well, definitely not this one, right? The case law that they're trying to to legislate against, overturn, is good. It's very well reasoned. The Walnut Creek versus Depositors Insurance case is very well reasoned, It was written by Justice Waterman, who is a relatively conservative pro-insurance justice, and it was unanimous. The whole court agreed on the opinion that they rendered. There was no dissenters. So maybe, consider that when considering this law and legislation in the future. Also, this law went through the House completely unanimously, right? It was presented by the insurance lobby and sponsored as a benign bill that simply clarified part of a fringe benefit of insurance policies. That's how it was presented. That couldn't have been further from the truth, right? So again, it went through the House unanimously. Now it's probably not even going to make it out of this subcommittee in the Senate, right? So that tells you one of two things. Either we're crazy in objecting to this bill as aggressively as we have, or it was presented under false pretense, and the legislators in the House did not do their due diligence in researching what the actual ramifications of this bill would be. So I'll let you guys make up your mind on which case is correct there. But as far as looking beyond this bill and what can be done, consumer protections has to be top of mind anytime any sort of legislation related to insurance, especially property insurance, is being considered. Because it's very easy to think, oh, this is going to, benefit consumers by lowering premiums. That's what every single every single legislation gets put on that boat of it's going to lower premiums. But oftentimes the cost in terms of consumer protection on the claims side is way more costly than what any alleged savings in premiums would be. So one thing that we're also struggled with after the derecho is the fact that insurers can put a 1-year statute of limitations on their policies, which quite frankly just does not give policyholders enough time to fight their insurance companies if they were underpaid or wrongfully denied, as well as make the repairs and account for any unforeseen damages or complications with the repair process. So having more protections that allow policyholders to have more time to take legal action against their insurance company beyond that 1 year would be really important. And then obviously looking to some of the other states that provide for recovery if the insured has to sue their insurance company for an intentional wrongful denial or underpayment of the claim is huge, because there's simply no reason that policyholders should have to incur thousands or tens of thousands of dollars to enforce the policy that they signed with their insurer to get a fair shake on their claim.
Absolutely. And I think that a lot of times insurance companies, they're risk assessment companies. Mm-hmm. And if the greatest risk that they have is to pay what they owe, then I think that's the thing to attempt to avoid doing. Obviously, they have an obligation to treat the interest of the policyholder in equal regard to their own interests. But they're risk assessment companies, man. If the worst thing that can happen is they pay what they owe, that's what they're going to fight against. If the worst thing that can happen is they pay 4 times what they owe, paying what you owe doesn't seem as bad anymore.
Right. Absolutely.
And I have a question.
Yes, sir.
How close is Minnesota to Iowa?
Right next door.
Yep.
So what do guys like y'all do? Do y'all like compare shovels? Like, get off like I have an articulating angle. Why do y'all choose to live in such a frigid area, man? Help me out. Hold on. Neither one of you. Hey, help me out, Caeden. I know you got what.
I'll be right back. I'm gonna grab some tissues.
Because y'all fighting for rights. The comedian head brain that I have says, at least now they have a reason to leave such a miserable place. But I know it can't be that miserable, right? Because y'all seem to love it. Can you tell me something about Iowa, Caeden, that like when you think about home, that's you like, all right, that's why I'm here.
Well, there's not a lot of Floridians in Iowa, and I think that's a big pro.
Ah!
You know, you never see the headlines Iowa man, right? It's always Florida man.
Got it.
You know, I had some neighbors when I was growing up that had moved in from like Texas, right? And come about September, October, they're like asking like, how cold is it going to get? Because it's starting to be 40, 50 degrees, right? We're like, oh, it's just the fall time, and then come November, it starts snowing and stuff. And they're like, is this as cold as it gets? Or like, nah, it gets like 40, 50 degrees colder. Come middle of January, there's a for sale sign in the front of their yard, man. They hightailed it out. But other than the weather, I mean, it's a fantastic place to live and to be. Iowa, Minnesota. I mean, it's great family values, a lot of strong economies that you're able to participate in up there, and stable economies, and good employment rates, which are all fantastic things for raising a family. But we're short a couple of beaches and some 78-degree days. We're short about 150 of those a year.
Yeah.
For my liking.
Because it literally snows, right? I think you and I were on the phone.
Yes.
And you were talking. I said, "Is it literally snowing?" And then you just started laughing, like only a Floridian will ask, "Is it literally snowing?" Right? So do the counterparts on appraisal not use the weather as a tool sometimes?
Oh, they totally do.
How?
100%. Well, there's an umpire on one of mine right now. I think I got it in October or November. And he's like, oh, I'm not booking any inspections until March. So in like middle to northern Minnesota, like that's legitimate because the snow never melts.
Yeah.
But in Iowa right now, there's no snow on the roofs. There's multiple opportunities. So that guy, that umpire that doesn't want to do that, honestly, his bones probably just hurt because he's old. And it's too cold for him to go out. So they do use it as an excuse. Absolutely. State Farm and others actually do shut down their exterior inspections from November to March ish in Minnesota, at least. So yeah, I mean it's legitimate. Sometimes it's over leveraged, but yeah.
Oh yeah, because that was one of the things that I worked in appraisal in Iowa, right? And and because I wasn't aware of how serious the weather is, because I'm only thinking about Florida weather. I'm doing my my negotiation thing, giving them as much time as they claim that they need, not realizing that the client time that he claims that he needs is just enough to get him to the snowy part of the season. How does somebody combat? Let's say if you're working in appraisal in Iowa or Minnesota,
Mm-hmm.
and it seems like somebody is about to leverage the weather, and it's not reasonable. Like you said, there's some parts in northern Minnesota where the snow never melts. But let's say you see that it's not reasonable. Is there no way to combat that?
I mean, I think you said it all right there. Appraisal is a communication, and you are trying to get the best overall outcome. Of course, there's always a way to combat it, but at what level of combativeness do you want to be in pursuit of that best overall outcome? And then also, what are the conditions that you've been informed of by your hiring party in relation to the appraisal? What is the time sensitivity and urgency that those hiring parties have, relayed to you? And so I think that those are considerations. But it can be absolutely legitimate. I mean, there are areas that are going to have snow for 4 or 5 months.
Mm-hmm.
And then also, just because there's not snow doesn't mean that the roof is in a proper condition to do a thorough evaluation.
Mm-hmm.
You may not be able to assess the repair difficulty factor, the RDF factor, on a roof if the roof is in a temperature climate that wouldn't permit an installation of that product. So how can you assess whether or not it's repairable if the weather isn't even where the manufacturer would allow that to be installed?
What do you think, Caeden? You feel the same way?
Yep, I absolutely agree. Weather is kind of like health in terms of it's not completely off limits in terms of being challenged if it's used as an excuse, but you definitely want to be reasonable with it, right? You don't want to be pressuring someone to go inspect a roof in the rain and cold, or a snowy or icy roof, or anything like that. I just had a situation involving a landowner that had half a dozen single family homes that are going through the appraisal process, and the insured's appraiser, they're my PA client, but it went through the appraisal process. The insured's appraiser drove from central Nebraska to eastern Iowa, where these losses are located. And then it was cold and rainy the day that he had planned on doing that inspection. And he didn't want to do them, but there was no need to go on any of the roofs. It was just a walk around. So I kind of said, look, it's neither of our fault the weather is the way it is, but do you really want to drive back out here again? I would really like these done. I know my client would really like these done. I know your schedule is busy, so if you don't do it today, it's not going to be for another couple months. So let's get it done today. And he did agree to do the inspections. He got them done. He didn't get the flu and die. He was fine. But sometimes some of these adjusters and appraisers can be a little bit of pansies, especially the ones that come from further south up here. But I'm going to apply a little bit of pressure as much as I can and deem as reasonable to get the job done. But, because otherwise we are operating on timelines. Just like I mentioned earlier, a lot of these policies have that 1 year or 2 year statute of limitations. So we can't afford to just toss away 5-6 months because all of a sudden we're out of time. So it's important to keep things moving, especially when we don't have the time, don't have the remedies, the leverage that people in some of the other states have.
Okay. Yeah. So it's y'all got, all right. So what I'm hearing is y'all, both sides have a healthy respect of the weather, and y'all more so lean toward, all right, it's better to be safe than sorry, because I guess y'all probably have seen some crazy things happen as a result to bad weather, being that y'all are natives from up there.
Well, I think that you just not gonna get on a roof that you're gonna fall off of. Plain and simple. Especially if it's snowy and everything. But have you ever been snowboarding, Randolph?
I have not. I imagine that I'm a natural, right?
Okay. I might have to get you out sometime, man.
I feel like as soon as I hit the slopes, it's gonna be like the flying tomato, like real easy.
We're gonna do a follow-up of this with like a video of Randolph going down and catching the toe of his board and just boom, face plant.
Yeah.
So both of y'all have been snowboarding?
Oh yeah.
I board.
Oh yeah. I board. So, all right, I got you.
I think you gotta find activities that help you enjoy the climate and have something to look forward to. Snowmobiling's a lot of fun. There's some good things.
And speaking of a lot of fun, usually, because we're all are vets when it comes to attending conferences, right? I think we've all been to our share of conferences so far. Usually, Caeden and I organically link up, because you're doing your network thing at conferences, right? But then there always is a couple people where you going to eat after this, or I'm over here drinking, come through, right? It's always that people do y'all have a strategy when it comes to networking at conferences? Caeden, do you have a strategy? Because you've done the vendor booth, you've done just the attendee. I've seen you done multiple areas. Do you have a strategy or no?
It kind of depends on the event, right? So what I would do at Win the Storm versus at, a NAPIA event are completely different. It kind of depends on who you're trying to meet up with and hang out with. And if you're actually trying to foster a business connection with, attorneys or with vendors like an engineer or something, you approach that very differently than if you're just wanting to hang out with friends and buddies and colleagues that you respect and enjoy learning from and being with, like you guys, right? So I wouldn't say I have a game plan going into every conference, but I'll choose whether or not to be intentional about fostering either of those types of relationships.
Derrick, what's your game plan? Or do you not? Are it's organic? What is it?
I think it's a lot of organic. Obviously, I kind of steer towards the more in depth technical conversations as well. But what do they say? When in Florida.
Yeah.
So, and I guess that applies to when you're around the Florida people too. So,
hey man, we try to make it fun, man. Absolutely.
I feel like I can always see the Florida people at the conferences. We walk into the bar or something like that because y'all just got a different vibe going on.
Oh yeah, I mean, majority of the year our bones are not frozen. It does something to you. All right.
I could see that. So, Caeden, back on this appraisal stuff here, just for a little bit. So, we were talking about derecho. You mentioned derecho. Derecho was a huge loss. What was the estimated loss, or roughly on that?
I don't remember in terms of insured losses. I think in gross losses, it was more than 10 billion.
Okay.
I don't remember. At one point in time, I saw a stat on how much collectively insurers had paid out. I don't even want to guess at it because I don't remember. But I'm pretty sure another statistic that I saw was that there was 50,000 claims filed within the first week after the derecho. So by and large, largest catastrophic event to have hit the state recently. So it was a very, very significant event.
And what was the date of loss on that for that storm?
Yep, that was August 10, 2020.
2020. So a little bit less than 2 years later, we see this legislation coming through where they're trying to remove appraisal rights after we just had the largest loss. So the people that are in Iowa, if they didn't have this appraisal or if this legislation was already in place, you said there was about 10 billion in damage. What do you think would have probably been paid out with no appraisal provision for the policyholder?
Well, from a large number standpoint, I can't even think. The only thing I can really reference to is the claims that we've handled and that we've brought through the appraisal process. So we handled about 350 derecho claims over the past year and a half, and probably a third of those or so have gone through. And let's say
Caeden.
Okay.
Let's just use 100,000 for an easy number.
Caeden, and you froze up. You said you had about 300 claims, and what did you say after that?
About a third of those went through the appraisal process.
Okay.
Yep. And so if the average claim was 100 grand and it was underpaid 50%, and that's conservative, that's 50 times 100. So I don't even know what the math is on that. 5 million. So yeah, 5 million gained through the appraisal process just on Swift claims alone.
Okay, which probably already had better settlement offers coming out, and it was still a little bit about 5 million. So it seems like it might be reasonable that a $10 billion loss to the property owners, to the citizens living in the state of Iowa, without any fee shifting for attorneys, without any bad faith or punitive damages, and with restricted ability to go to appraisal only over what the insurance company has agreed is directly damaged as a result of this most recent storm, could take that payout number down to less than 500 million. Maybe even 200 million might be what they'd actually pay out.
Yeah, I mean, you can do that math a number of ways, but
I'm gonna take his word for it.
yeah, and you're not even considering the fact that insurers still, even with the knowledge of the appraisal process being a viable remedy, still underpay claims, knowing full well that it could get resolved by going to appraisal. Take appraisal off out of the tool belt of the policyholder for getting paid what they're owed, and all of a sudden it's even more tempting to underpay these claims because it's even less likely that the policyholder is going to be able to fight it, right? So I think the situation would get even worse.
And that's right back to that risk assessment thing that carriers do really, really well is,
Yep.
All benefit. As if they're interested in profit, then it's all benefit.
Yep.
Y'all see me having fun with these angles?
Yeah. Man.
All right, so just so I can understand, Caeden, if this bill was to pass,
Mm-hmm.
does that mean that appraisal does not exist?
No, it would still exist.
Okay.
Right. So this bill, it doesn't remove the appraisal process. It's a very short, brief bill. It's only like 2 paragraphs. It simply states that the appraisal panel cannot determine causation as well as coverage, but appraisal panels don't do coverage anyways. It takes away their ability and the precedent that's been set for decades of the appraisal panel to determine causation. So while it wouldn't take away the process, it would effectively render it feckless. Like there would be no point, because 90% or more of disputes over the amount of loss are issues related to the cause of the damage or the scope of the damage resulting from the cause being claimed. So if you can't get that resolved in appraisal, what's the point of even going? Because you're going to have to sue anyways.
So, and the attorneys are the attorneys incentivized in Minnesota to take bad faith claims, or is there no financial benefit to them to take these claims?
Yeah, in Minnesota, it doesn't seem like there's much financial benefit to take those claims. There's some statutory provisions that seem to allow for a payment. However, we were talking about the cause of action. Just violating the Fair Claims Practices Act is not a cause of action. And it seems that appraisal is a prerequisite to litigation, and the amount available for recovery for those punitive damages is the difference between what was offered prior to the jury trial and what the actual jury award is. It's 50% of that difference. And if amount of loss is determined by appraisal prior to a court proceeding, I'm not sure how we get a difference there.
So what do you think, Caeden? Is it hard for you to get an attorney to go? Because I know if anybody is documenting the file correctly, it's you and your team.
Mm-hmm.
Is it hard for you to get an attorney to take your files?
Yeah, absolutely. It's simple economics. It's the law of diminishing returns. There's 2 ways that attorneys take files, either hourly or on a contingency basis. That contingency basis might be a hybrid model. It might just be a straight percentage of the recovery. But from an hourly basis, you rarely see that because the policyholders don't have the funds to pay a retainer to an attorney. So in this context, most attorneys work on a contingency basis. A third or 30% is probably about the average for what they do that at. If they're looking at the risk of having to take this case all the way through trial, through appeals, they're not going to want to have a pool that's smaller than probably 30 grand to cover their costs, 25, 30 grand. So we don't see attorneys taking claims on contingency that are less than $100,000. Doesn't matter how good the facts are. The attorneys can't afford to do it, to take the risk of having to take a case through trial and through appeals and through experts and all sorts of other court costs and whatnot, without having that potential at the end only be $10,000 on a $30,000 claim. It just doesn't make any sense to do so. So really, for anything under $100,000, which is going to be, probably 90% of claims, most small and medium-sized claims, attorneys won't touch them.
Yeah, and to me, it seems, because would you say y'all are considered middle America?
Yeah.
And I know insurance companies use the law of large numbers, right? In order to basically, they use the law of large numbers in order to stave off adverse selection. Because basically, the more you're able to get homes insured, you know that if you can count on middle America not having any recourse, you're okay with the outskirts, the ones who deal with the ones that actually show up on the news screens, right? Because the only reason I know that a derecho exists is because I know you. I didn't necessarily see it on the news, but when a hurricane or a tornado hits, it's all over the news, right? It's subjective versus objective information. It seems like if somebody was a conspiracy theorist and they believe that things might look different on the surface, but the same underneath, it might be a reason why attorneys in your areas, because I believe it may be Minnesota too, don't get the same treble damages that attorneys in other areas get.
Yeah. Ultimately, the history of that and the reasons for why that is beyond my expertise. All I know is what I see as far as ramifications for the policyholders, for the consumers, and it's not good.
Yeah, I mean, I think if you go into a room with 100 Texans and you steal $100 from every one of them Texans, you might not make it out of that room. Now, you do the same thing in some other areas, and I think our consumer protections, unfortunately, may model that. Because you would think that in some of these areas that are supposedly more liberal, the consumers would have more protection, and they don't. They don't. And in Iowa, they're about to have no protection if this goes through. I mean, basically, because if you really get that, if the insurance company says, yes, that shingle is damaged, but it's damaged from a bird running into it or just whatever ridiculously thing they come up to, that's not an appraisable issue if this legislation goes through. Mm-hmm. You cannot appraise, what caused the damage. And then if they say those 8 shingles are damaged, however, there's no ability to repair it. The material is not available. There's no ability to make any type of repair that's going to put them back to pre-loss condition and alleviate them of financial detriment. However, the only thing that you're going to be able to go to appraisal for is going to be those 8 shingles. It's such a massive restriction, and that's why I want to talk to Caeden about this. It would be such a massive restriction on the rights of the average policyholder.
Yeah. You guys want to hear an example of, a case like this?
Absolutely.
Yeah, so I'm working on one right now. We actually just got a revised estimate back, which is wonderful for the interior damage. But it is in Coralville, Iowa. It is on a street that had some higher-end homes, not custom. They were all built by the same builder and relatively similar, but nicer features. So this particular home has an engineered rubber products roof, which they're out of business now, but they're similar to like an EcoStar or a Da Vinci or Brava. They're a synthetic type tile. And when the derecho came through, it lifted a bunch of these tiles, resulting in a leak, as well as some cracking and pull through of the fasteners on those tiles. Well, the insurer, they never even sent an adjuster out. They went straight to an engineer. And that engineer not only misidentified what that product was that's installed on that roof, but stated that the cause of the cracking on those shingles, on those tiles, those synthetic tiles, was installation error. He claimed that the nails were overdriven, and that was the result of the cracking. Well, I don't agree with that, right? The tiles are pulled up and cracked in a fashion and location that's very consistent with wind damage and the direction of the wind. There's no real evidence that the fasteners were overdriven in that area of the roof compared to any other area of the roof. The cracks look fresh relative to the oxidation and fading of the rest of the tile. So it would be strange for this roof that's going on probably about almost 15 years. They were built right around the time of the crash in 07 and 08. But it just doesn't make any sense that it's the result of installation error. It's every piece of evidence is pointing to it being wind damage, but the carrier refuses. They say, nope, it was caused by installation error, therefore it's not covered. If this law were to go through, that issue could not be subject to the appraisal panel. And that's what's probably going to happen on this claim. It's not there yet, but it's very likely that this claim is going to go to appraisal, and the appraisal panel is going to look at the same evidence that I did, the evidence that Nationwide never looked at, their engineer looked at, but we all know that those engineers are deep in their pockets and write what the insurers tell them to write. And hopefully that appraisal panel, consisting of experts and impartial, interested experts, as well as the neutral umpire, will conclude that the evidence points to wind as being the cause of the damage to that roof, and it will be included in that award. If appraisal can't do that, right, in that appraisal process would probably be a couple grand. It's really only the roof that's in dispute at this time. They covered the interior damage, which is ironic if they're claiming that the roof damage is not covered. But it doesn't matter. It's probably going to be a few grand to get that appraisal process done. If this had to go to litigation, the insurance company is probably going to hire another expert. The insurance is going to have to hire 2 experts to counter the engineer, as well as the other building consultant. They're going to have to go through depositions about, the condition of the roof, all that sort of stuff, and then trial. And that's going to be tens of thousands of dollars to do that versus a couple grand for the appraisal process. The appraisal process is going to take a couple months. Litigation would take 2 years at minimum. Right now, they're scheduling in 2023, just the initial court dates.
Wow.
So it's not a complex issue, this claim. If they had sent out an adjuster in the first place, I think it would have been paid correctly. But they didn't even do that. They just went straight to engineer because for whatever reason, they wanted to fight it. And the engineer's wrong. That's just the simple truth of it. So appraisal needs to be protected for instances like this and tens of thousands of other claims with identical sets of facts.
So if I'm hearing you correctly, the roof was in place since 2008. 14 years later, it starts leaking after a storm.
Yep.
And people probably, maybe not everybody knows, you can tell when something looks fresh or when something's not. There are several signs to that. So there's fresh damage to the roof that the engineer is claiming was a result of the installation and faulty installation. Okay.
14 years ago.
And I've literally recently had an insurance adjuster tell me on the phone, I don't agree with you. I'm going to go hire an engineer that will agree with me. And I'm going to send them to do the investigation. So insurance company adjusters literally look at engineers as, I don't want to pay this. And I'm saying this, they literally look at them as, I don't want to pay this. I'm going to hire this expert who is quote unquote independent and unbiased, but will only do what I dictate to them to do under the terms and standards that I tell them to do them under, to go and agree with me. So I have another reason to not pay. And then I'm going to just review that information and not pay it based off of that. And it's a huge issue because they look at either they want to properly extend coverage and pay what they owe, or they want to defend the position and not make a payment. And as soon as they send an engineer prior to an inspection, you already know they want to defend that claim, which means they know the value of that loss. They know the premium that they wrote. They know what they're on the hook for, and they don't want to pay it. So they're saying, okay, we can pay this $85,000 out to replace this roof and this $28,000 to cover this interior damage, or we can pay this $3,500 to this engineer and tell them to kick rocks, pound sand, and good luck getting paid.
Do the math.
Yeah, and it also sounds like there's really not a benefit to the policyholders, to the property owners in Iowa, and to the attorneys to take the cases to litigate it, because you're not going to get the attorney fee shifting. So they got to have to foot that bill. And then regardless of the action that the insurance carrier has taken, they're not going to get paid that punitive damages for that damaging and suffering and having to go through all those depositions and take off of work and the stress and agony that's caused them. There's no penalty to that. So the insurance company can knowingly not follow the policy that they have in place. They can knowingly deny coverage that they know they should pay for. They can knowingly, misrepresent pertinent facts of the loss and have no penalty for doing it, other than the fact that they make more money, or worst case scenario, they pay what they owed on day one.
Exactly. Yep.
Crazy. That's the crazy stuff, Randolph, up here. And that's the things I think that hopefully some legislators watch this and take the time to get the understanding that interest in preservation of the policyholders and preservation of every citizen that they're in office to be serving. Policyholders having more rights and having a fairer shot at recovering, because insurance is meant to insure you against loss, right? It protects your home, it protects your asset, it protects your business. And if that insurance company refuses that payment and that policyholder has to pay, they paid $30,000, $40,000 in premiums for their life. They have an $80,000 loss. Now they got to go pay that $80,000 loss. That's coming directly out of the retirement fund. That's coming directly out of their college, their kids' college fund. They're not going to take that family vacation. You're destroying the lives that people have worked their butts off to build and have insured with these insuring companies.
And just to clarify, it's not about policyholder. In my opinion, it's not about policyholders having more rights. It's preserving the rights that they already have and have had. Like when you, I think you mentioned the original 165 line policy.
Yeah.
That policy was clear, to the point.
Mm-hmm.
Yep.
And then as it's funny how the more words, the less rights. You would think it would be the other way around. It seems counterintuitive, right?
Mm-hmm.
With more words, there would be more rights. But it seems like with more words, rights are steadily getting taken away. U.S. versus Mitt Ferguson said that insurance is ultimately controlled by the federal government, right? But it's still regulated by the state. All the states, when that happened, adopted the federal approach. But like you said, depending on who was in each state started going off in their own path. If we allow what they say a threat to justice, injustice anywhere is a threat to justice everywhere. If we allow the middle America, the people who got to shovel their snow, y'all already got it bad enough. If we let them take away the rights for appraisals to determine causation, and just so people know, that's a big deal, because causation, if you, it's like a trickle down effect. If this is what caused it, and we have to fix this, which is based off what caused it, and based off the doctrine of proximate cause, we have to do this, and then this, and then this. If they're saying that we're not able to use our minds to do that doctrine of proximate cause in order to make sure that the scope is correct, when everybody, everybody likes to claim that they're unbiased. Everybody has a hint of bias. You can say whatever you want to say. Everybody has.
I'm unbiased.
I'm completely unbiased. Blah 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 blah. But if everybody beforehand, because the way it was explained to me, because I've done multiple appraisals and I've had the benefit of engaging umpires, very wise umpires. I had the great benefit of engaging very wise umpires to where they basically break it down. Yeah, you be more conservative at the beginning, but as it gets towards appraisal, a process that's supposed to be binding, you're supposed to be more liberal. Because if we put this stamp on this and this is done, what recourse do they have? Mm-hmm. Appraisal needs to be more liberal than it was in the beginning. Okay, I get it. It's a negotiation. The initial adjuster that came out is just the first level of negotiation. We know this, but when it gets to the end, let these people actually use facts and use supporting documentation and use their minds and use their words in order to determine what. All right, all that aside, let's use facts. If you're going to take that away from them, like you are already insinuating and not just insinuating, outright saying, Caeden, you pretty much take the whole goose. Seems like.
Yep.
Yeah.
That's amazing, man. Hey, Derrick, I'm glad you brought this to my attention. Right?
Yeah.
Caeden, I'm glad that you're not just taking it. Right? It seems like you're about to do everything it can, because when we reached out to you, you did not hesitate to come on and talk about it. Thank you so much for sharing that.
Absolutely.
And it looks like your screen probably froze on us again. It's and then on the next podcast, we're going to talk about Iowa internet and how we need to preserve.
Now, is it true? Because one thing about being up in the north is that the winter comes and the bugs die. So I hear y'all got some ginormous, and I've seen some ginormous insects down south.
Yeah. So first and foremost, you have to be above the Mason-Dixon line to use the word ginormous. All right. So first and foremost. Secondly, if worse comes to worse, those bugs are protein, man. You never seen Timon and Pumbaa? Like, we have another layer of resources to survive if a pending plague were to hit. That's the way I see it.
I promise you, I'm going to test that theory. Next time I see you, I'm bringing some chocolate-covered grasshoppers. We're going to test this theory out.
Hey, Caeden, man, Darrick, thank you so much for hanging out.
Appreciate you.
And Caeden, hopefully, we see you at the second annual Path to Indemnity Conference coming up this May 18th through the 20th. I'm not going to put you on the spot, but hopefully we get to hang out on the conference scene again.
It would be my pleasure.
Oh, you see how he said it would be. He didn't say it will be. I'm going to let him go because I'm not going to determine causation on what made him say it like that. All right.
That's not an appraisable issue, sir.
It's not appraisable, especially if this bill passes. Hey, thank you so much, Caeden. Thank you so much, Darrick, for hanging out.
Thanks to both of you.
Thank you both as well. Thanks, Randolph. Thanks, Caeden. Take care, man.
Yep, you too. Bye.
Bye-bye.